So welcome everyone to the week 10 tutorial on judicial review remedies. We only have 2 weeks to go. Wow, that's pretty quick. And well, I'm almost certain that all of you, hopefully, should finish this unit with good grades. And I'm very happy that I've been with you for the past 10 weeks to guide you in a journey to learning more about administrative law. And so tonight, we're covering the last part about administrative law, particularly about the judicial review, and we've covered merit review as well. Judicial review remedies would be a very important topic, mainly because although you might be able to identify the grounds for judicial review, you might even be able to say that a person has legal standing, and you'd probably be able to say as well that that the issue is justiciable, meaning it is a legal question that is apt for the court. We know that one of the crucial requirements to determine when you examine the possibility or the propriety of applying for judicial review is whether or not there are judicial review remedies that are available that would be able to address the aggrieved party. So where are we now? Try through always the quickest. Okay. And so this is also important to point out, therefore, that whilst when we had the midterm assessment, our focus was whether or not judicial review was available, and essentially, the midterm assessment tried to ask you to identify the grounds for judicial review. And we, in the midterm assessment, we were looking at an authorized decision-making and natural justice as possible grounds for judicial review. The crucial point about the final assessment is that not only must you be able to identify a ground for judicial review if there exists one, but you need to be able to identify as well the specific judicial review remedy. So in other words, for the final assessment, it will not be acceptable for the purpose of you getting a good mark to just say that, on the basis of the fact that there is a ground for judicial review, then, my advice would be to advise the client to apply for judicial review. Your job is to be able to identify the specific judicial review remedy. And oftentimes, being able to identify the specific judicial review remedy can be tricky, because you need to know the legal basis for the judicial review remedy. In other words, are you basing it on the ADJR Act? Are you basing it on Section 39B of the Judiciary Act of 1903? Or are you basing it on Section 755 of the Australian Commonwealth Constitution? Or are you perhaps basing it on common law judicial review remedies? Because, for example, if you base it on Section 755 of the Australian Commonwealth Constitution, which relates to the power of the High Court to grant writs of Mandamus, prohibition, or injunction against an officer of the Commonwealth, and it has a corollary, a similar provision in Section 39B of the Judiciary Act 1903, which relates to the power of the Federal Court of Australia. We notice, therefore, that in relation to Section 755 of the Constitution and Section 39B of the Judiciary Act of 1903, the possible writs are limited to prohibition, mandamus, or an injunction. But we know when we look at judicial review remedies that there are other possible writs. So it could be, you might need the issuance of a writ of certiorari. You might need the issuance of a writ of habeas corpus. And there are other possible judicial review remedies that might be needed, including, for example, the writ of declaration. And so, having said that, therefore, it means that, what if you're not asking for the issuance of writ of mandamus, prohibition, or an injunction, but you might need a declaration, but that is not among the powers granted by a court under Section 755 of the Constitution or Section 39B of the Judiciary Act. So in that case, you would have to rely on the common law judicial review remedies. So when we speak of the common law judicial review remedies, we are reminded that, since about the 1300s in the UK, the courts have already asserted their power to be able to control and regulate the exercise by the executive of its powers when the exercise of those powers would constitute a breach of the law. So when there is illegality in the actions of the executive, the courts have asserted the right to step in to prevent the violation of the law or to prevent abuses by the executive. So we have the common law judicial review remedies, therefore. So we need to examine that. And in relation to that as well, there is that aspect of trying to determine, when the executive makes a decision, is the executive making a decision on the basis of a statute, so that potentially you can rely on the ADGR Act, or is the executive making a decision on the basis of implied powers of the executive or prerogative powers of the executive? And again, in that case, if the executive is relying on his implied powers, you cannot have recourse under the ADGR Act. So judicial review remedies as a topic can be quite complex, and we will try to examine a few of these judicial review remedies tonight. So again, as a reminder for the final assessment, and I will emphasize this again when we have our week 12 tutorial, which will be about revision, I need to emphasize that in the final assessment, it is insufficient for a student to just say that I would advise the client to apply for judicial review. The student must be able to identify the particular judicial review remedy that should be applied for. Okay, it's not sufficient to just say you can apply for judicial review. That was fine, the midterm assessment. It is insufficient for the final assessment. So we need to clarify that. And that's why we need to discuss this topic tonight. So after studying this topic, you should be able to discuss and explain the distinction between common law prerogative judicial review remedies and equitable judicial review remedies, the specific common law prerogative judicial remedies of certiorari, mandamus, prohibition, and habeas corpus, and the specific equitable judicial remedies of declaration and injunction, and the statutory judicial review remedies on the basis of the ADGR Act, as well as Section 39B of the Judiciary Act, and even the constitutional review remedies under Section 75(5) of the Australian Commonwealth Constitution. I've prepared 6 questions for tonight. So hopefully we will be able to cover them all. Now, before I continue, would there be any questions from among you or any comments you'd like to make before we proceed? So we're good. Hang on. Did I include the quiz question here? Give me a second. I may have forgotten about that. Oh, yeah. I forgot about it. Okay. Give me a sec. Let me remedy that. I had a feeling I forgot about it. Let me just look it up. Okay. That will make it 7 questions then. Give me a second. Copy, paste, quiz. What? Okay. Sorry about that. I forgot about this. I was too drawn to just coming up with new discussion questions. I forgot that there is a quiz, which we're meant to discuss. Okay, so we'll try to cover all the 7 questions, including the quiz question. So can we just begin? What date is week 12 to revision to tutorial? That's going to be 2 Thursdays from now. It will be before the take-home paper. Okay, So can I get somebody to read quiz question 1 for us? And then we'll take it from there. Can I get a volunteer?
I will. I'll give it a
Thank
try.
you. Thank you. Who was that?
Mary.
Oh, Mary. Okay. Thank you, Mary. Yep, go ahead.
The Australian Minister for Small Business, the Minister, reported at a session of the Commonwealth House of Representatives that he had in her possession a special report about small businesses that are likely to be involved in money laundering and organised crime. He said that in due course, he would submit a bill and attach and publish the special report thereto. That would introduce more severe penalties for small businesses that are involved in money laundering and organised crime. On the basis of a Freedom of Information Act request, XYZ Proprietary Limited was able to acquire a copy of the special report that it feared named it as one of the small businesses that was alleged to be involved in money laundering and organised crime. Fearful that the release of the special report would damage its business reputation, XYZ Proprietary Limited has come to you, a solicitor, for advice. XYZ Proprietary Limited is aware that the Minister is not exercising a statutory power in seeking to publish the special report. Which of the following statements is the most correct?
Okay. And then when the choices come up, please continue reading, Mary. Thank you.
They haven't come up yet.
Okay.
Okay, so A, XYZ Proprietary Limited should be advised to apply for the insurance of the writs of prohibition and injunction in an application for judicial review with the Federal Court of Australia under Section 39B of the Judiciary Act 1903 Commonwealth. B, XYZ Proprietary Limited should be advised to apply for the insurance of the writ of Mandamus in an application for judicial review with the Federal Court of Australia under Section 39B of the Judiciary Act 1903 Commonwealth. C, given that the special report has not yet been published, XYZ Proprietary Limited has no legal standing to apply for the judicial review. D, the publication of the special report, even if it identifies the small businesses that are alleged to be involved in money laundering and organised crime, is a non-justicable question and not apt for judicial review. E, XYZ Proprietary Limited should apply for judicial review under the Administrative Decisions Judicial Review Act 1977 Commonwealth of the Minister's decision to publish the special report about small businesses that are likely to be involved in money laundering and organised crime.
Okay, thank you, Mary. So can I ask everyone to provide an answer to the quiz using letters A to E? Oh, so this quiz, its end date is 30 September 2019. Okay, I'm gonna have to fix that. Thank you, Travis, for pointing that out. I'll have a look. So we've got an answer, A from both Damien and Sarah Rogers, D from Kayla. Okay. From Sarah Goodchild, A, Nicholas, A. Okay. A from Mary as well. From Travis, it's A. Okay. So okay. So before we go to the correct answer, why did we exclude letters B, C, and E? Can I just get somebody to explain that, and then we'll focus on the answer A and the letter A and D answers, because students have chosen A and D, but not B, C, and E. Can I just get somebody to explain why not letters B, C, or E? Okay, so from Michael, C, doesn't matter, it isn't published yet. So given that the special report has not yet been published, XYZ Proprietary Limited has no legal standing to apply for judicial review. Okay, okay, okay. I see what I mean. Okay. Yes, what do the others think? Go on. So from Nicholas, it cannot be B. I think this is what Nicholas is saying, because Mandamus is a writ issued by a court to compel an officer or an administrative body to command the fulfillment of some duty of a public nature which remains unperformed. So why not B?
Because a writ of Mandamus is basically in order to make somebody do something. I mean, they don't want to make XYZ Proprietary Limited don't want an action to happen. They want something to stop happening.
Okay.
Can't a Mandamus correct an abuse or a discretion as well?
What do the others think? Can Mandamus be used to correct the exercise of discretion? It cannot be Mandamus, because really Mandamus can only be issued as a writ when there is a clearly defined right on the part of the applicant on the basis of the fact that a particular executive failed to perform a duty required by law. So there has to be a duty on the part of the executive to perform a particular duty which relates to the right of an individual. So if the right is not clear, if there is no clear right on the part of an individual, or it is not clear that the executive really has a duty of a public nature that has not been performed, then in that case, there can be no Mandamus. So if there is a level of discretion on the part of the executive to perform a particular duty or not, Mandamus will not lie. So Mandamus will only lie when there is a duty on the part of the executive to perform, in a particular way. But if there is a discretion, or two, when the right of an applicant to the performance of a particular duty on the part of the executive is not clear, then you cannot have Mandamus. From Nicholas, Mandamus, in the course of attempting to discharge it, has failed to comply with some requirement essential to its valid or effectual performance. He may be commanded by the writ to execute his function according to law de novo. Okay, so it cannot be Mandamus. Okay, let's choose between A and D. Let's look at D. Why? So the publication of the special report, even if it identifies the small businesses that are alleged to be involved in money laundering and organized crime, is a non-justiciable question and not apt for judicial review. Is that a correct answer? Some have chosen D. We've got about 3 students choosing D. Is that a correct answer?
I think it is a justiciable decision because it's an executive decision that affects the rights of a member of the public or a business. So therefore, basically, anytime that occurs, there's possible grounds for judicial review.
Okay, thank you for the Damien. When we speak of justiciability, there are actually 2 aspects to the issue of justiciability. One is the one we heard about, an issue or a matter becomes non-justiciable when the executive decision is really based on a national policy or involves a political question that the executives as elected officers of the government are best in a position to decide. So that becomes non-justiciable because it requires policy making, it requires a political decision. So, for example, whether the nation should go to war, whether the state should enter into a treaty, these are non-justiciable questions. They involve political questions. Whether or not taxes should be raised, that's a political question, which only the executive, as decision makers, elected representatives of the people, can decide. But the other aspect of justiciability is what is related to the concept of matter. So we need to recall that under the Constitution, the way we understand the Constitution, courts can only have jurisdiction in relation to a matter. So there can only be a matter when there is an actual controversy involving the potential violation of a right, an obligation, or a liability. So that is this is the classic case of Moorhead, Huddart Parker versus Moorhead. So that's the definition. So in other words, when there is no matter, when there is no actual controversy involving a citizen, the violation of a citizen's rights, interests, or liability, then there can be no jurisdiction on the part of the court, because courts can only have jurisdiction in relation to a matter, and that's in the Constitution. In matters, so that's the provision of Chapter 3 of the Australian Commonwealth Constitution, which means, therefore, that if what is involved is hypothetical, it is theoretical, or there is actually no controversy, then you cannot have judicial review. So are we clear? So in this particular case, there has to be a matter here. There has to be an actual controversy, because can you imagine the potential damage to the reputation of this particular company? And as pointed out by Sarah Rogers, in Ainsworth, reputation is a right. So if Parliament were to publish a report, that would violate if the Australian Minister for Small Business were to publish a report, that would really impair and diminish the reputation of the company. So there would have to be an actual controversy, and that case was decided as well in Ainsworth versus Criminal Justice Commission. Now, so why letter A? What would be the basis for an application for the issuance of the writ of prohibition and injunction? Why not the, did we say ADGR here? So why not the ADGR Act?
Well, it hasn't been published yet, so that's why you're asking for a prohibitive injunction, because it hasn't actually been published.
Okay, but I mean, why can't we have a recourse? Why can't XYZ Proprietary Limited have a recourse under the ADGR Act? Correct. From Kayla, it is because the actions of the minister, was it? The actions of the minister were not going to be based on a statute, but on the exercise of non-statutory power, or the exercise of prerogative power. So when the executive exercises implied powers or exercises prerogative powers, it is therefore not based on statute. And if it is not based on statute, the ADGR Act will not apply. It cannot be letter E. Okay, so, but why prohibition and why injunction? When are these remedies available in the first place?
Manjo, can I speak?
Yes. Who was that?
It's Kayla.
Kayla, yes.
It's because prohibition corrects a legal error before something occurs.
Okay, and what exactly is the nature of a prohibition when you say correct a legal error? What exactly does a writ of prohibition? What is the effect of a writ of prohibition?
The injunction.
Yes, it's about restraining a decision maker. So it restrains a decision maker. So it would prevent a decision maker from, in this case, the minister, from publishing the report. Okay, so the writ of prohibition is available under Section 39B of the Judicial Act against an officer of the Commonwealth. And we know, following judicial precedents, that prohibition would be available in order to prohibit further unlawful action on the part of the executive. In this case, there's clearly unlawful action on the part of the Minister for Small Business in attempting to publish the report, because it would damage a reputation of the company, which we know is a protected right to reputation, as stated, as recognized by the High Court in the case of Ainsworth versus Criminal Justice Commission. The nature of an injunction is also available, because the advantage of injunction, because it is an equitable remedy, is that it can be fashioned. So the prohibition restrains, stops, prohibits a decision maker from doing something. So it will prevent the minister from publishing it. But the injunction, as an equitable remedy, can actually be fashioned by the courts to meet the particular needs of XYZ Proprietary Limited. It's not just a question of stopping him from publishing the report, but perhaps saying, you cannot do this, you cannot do that, you cannot do this, you must also do this. Can you see the difference?
Manjo.
Yes. So the two are related in the sense that they restrain, but the injunction is more powerful because it can be fashioned in order to meet the requirements of a particular case. Yes, Nicholas.
Yeah, Manjo, just a quick question in regards to that answer.
Yeah.
We're talking about prohibition, but I thought prohibition, as I've put up there, is a writ issued by a court to restrain an inferior court or a decision maker, right? In this case, there hasn't been a decision by anybody in particular, and it hasn't been presented to a court as yet. So how can prohibition stand? The only option would be an injunction, wouldn't it?
No, because we're talking of a decision maker. We're not saying a decision maker has made a decision. There is a decision maker. In this case, is the Minister for Small Business. And in the particular case of Ainsworth versus Criminal Justice Commission, which almost involve the same facts, the High Court was quite clear that Ainsworth was entitled to the issuance of a writ of prohibition to prohibit the Criminal Justice Commission from publishing a report that was defamatory and would end up, impairing the reputation of Ainsworth. So injunction can immediately stop, prevent a decision maker when no decision has been made. But in a situation when there is about to be a decision made by the decision maker to publish a report, prohibition can be applied for, following the case of Ainsworth versus Criminal Justice Commission. So thanks for clarifying that. Questions? Yep, so for Michael, the prohibition would restrain an inferior court or a decision maker made but not yet executed. So that's to restrain, to stop. Okay, so so the answer here is A, but again, we need to remember that as far as the quiz's answers are concerned, they're being shuffled. Okay, so don't rely on the letters here. You need to rely on the actual answer. Okay. Question 1. Can I get somebody to read question 1 for us?
And just before we move on, I think it was Nicole that mentioned it, and it's just it's more of an administrative thing. I think our week 12 lecture is actually scheduled to go on after our take-home paper.
Is it?
Yes. Next week being the 31st, which is week 11, and then week after is the 7th. So
okay. Give me a second there, Travis.
12 hours earlier, we would have submitted it.
Let's have a look. Okay, give me a sec. 6 February.
Through to the 7th.
Oh, right. So that's actually week 12. Okay.
I'd like to actually hear your review before I've actually got to do the final paper.
Okay. So what we're gonna do, if you don't mind, we could have the revision on a Monday. Would that be all right? So we'll do a revision on Monday, which is February 4? Okay, very good. So thanks for pointing that out. I really missed that. So I don't know what happened. I missed that.
Some of us have, if we're doing some other subjects, we've got at 6 o'clock, we've got another subject on Monday at 6 o'clock, which is revision for the whole term.
as well. So, well, for the students who are somehow unable to join our revision on Monday, on the 4th of February, it shouldn't have to be much of a problem because we're going to be recording the tutorial anyway. So you can just, have a look at the tutorial recording. And if you happen to have any questions, then, send me an email. Or you can post it in the discussion forum.
So long as nothing's gone wrong, because we've had other subjects, I've had other subjects just recently where that has gone very wrong, and recordings have been lost and haven't been put up. So
I'll make sure that there is a recording. In the event that there is no recording, I'll make sure to come up with written suggestions, extensive written suggestions, because that's what I intend to do for the revision. I'd like to assist students to come up with better answers for the final assessment, not only for them to get better grades, but also because I'd like to provide some more guidance in relation to providing answers using the IRAC format. So I'll make sure to have the recording, and somehow if there is a problem with the recording, I'll come up with extensive written suggestions in the form of a revision.
Manjo, could you just shift the final exam forward a week to the 13th?
No. It can't be done. I don't have the power for that anymore. The moment the final assessment has been published, and remember the dates for the final assessment were something that was discussed in the law discipline by our colleagues. So we have to timetable them. We don't just do it arbitrarily. And once the schedule of the final assessment has been published in the unit profile, no unit coordinator has the power to change it. It can only be changed upon the approval of the Academic Services Division and the Deputy Dean for Learning and Teaching. So I don't have the power to change anything.
Plus there's exams on the 12th, 13th and 14th anyway, which are evidence in corporations.
True. I think that was the reason why I set the final assessment on the 6th of February, because there was going to be the final exam the following week. The problem with the trimester is that, schedules are just too cramped, and it's difficult to find the time. But I suppose that should work, right? If we're going to have the revision anyway on a Monday. Okay, so we could move on to question 1. So thanks, Travis, for raising that. And who else?
So can I just ask?
Yeah.
On Thursday the 7th, now there will be no tutorial at 6 p.m.
Yeah, there won't be any more tutorial because we're gonna have the tutorial on the 4th.
It'll be on the Monday.
Yeah.
It's corporations law, so we have to make a decision about which one we attend. Okay, thanks.
Yeah, but I mean, in the event you're unable to join our tutorial, it's going to be 6 p.m. Queensland time on Monday. So we're going to do it on Monday. I'm going to make the announcement anyway. We're going to do it on Monday, February 4 at 6 p.m. QLD time. I'll make the announcement. As I said, in the event you're somehow unable to join that,
can it be done at 7 p.m. Queensland?
I don't have a problem with doing it at 7. Does everyone prefer 7 p.m.?
That would tie in straight after corporations law, but if you can't, you can't, and then we'll just someone's got to choose priority, that's all.
So do you, because I don't have a problem with 6 or 7. Do you suggest 6 or 7?
7.
7, because we've got corps at 6.
Okay, so we'll do it at 7 then?
Yeah.
Okay, so 7 p.m. on February 4, Monday. Okay, Queensland time. Okay, very good. But as I said, don't worry. Lauren said, you can always watch the recording. Very good. Now, if we run out of time, because we're meant to end at 7, I don't mind, continuing with the tutorial until we cover all the questions. I don't mind that, if you're happy to hang on, because we're kind of running out of time right now. Okay, so can we proceed to question 1? Can I get somebody to read question 1 for us?
I'll go. Darren Wilkins operates a car rental business and he has been doing most of the business accounting tasks on his own. An audit by the Australian Taxation Office revealed that he had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of almost $60,000. The ATO informed him that under the relevant tax laws he must pay his tax deficiency within 15 days or would garnish all his business and personal bank funds. Darren has come to you as a solicitor for advice. Advise Darren on the judicial remedy or remedies that are available to prevent the garnishment. Or ask ATO for an extension like every other business does.
Okay, that's one. That's one idea. So, but imagine this situation, right? The ATO is about to garnish funds. And can you imagine the impact on a business if the funds are garnished? There won't be any money to pay suppliers, no money to pay employees, and so on. That could be really problematic. What advice would you give? I mean, you could always ask the ATO to ask for, for an extension. But what if the ATO refuses? And here they are saying that they are about to garnish the funds, both the business and the personal funds of Darren Wilkins. What would you suggest?
I'll have a go. I think, assuming that there's no appeal avenue through the ATO, he can apply for a writ of prohibition. Basically because if there is an appeal avenue, then he's not allowed to apply for a writ of prohibition on the ground of not being afforded procedural fairness.
Very good.
I'm not entirely sure. I think would it be through the Judiciary Act?
Go on. Yeah, because you need to identify the basis for the judicial review remedy. What's your source?
Yeah, so I'm going to take a flying stab in saying that it's the 1903 Judiciary Act. Because it says, what does it say, under the relevant tax laws? So that sounds like it's statute, but I don't know if that matters.
In this particular case, we're assuming that because it doesn't say that it's actually based on. It doesn't say that the actions of the ATO are actually based on an enactment. It doesn't say.
Doesn't have to. Isn't taxation under the Constitution an act of Parliament anyway, and only an act of Parliament? So it could be the High Court. It could be a High Court issue too.
Okay.
Yeah, but this is not an act of tax. What we're talking about here is not an issue of taxation. We're talking about here an issue of debt collection.
Garnishing. Yeah, so the decision is the actual decision that you'd want the writ issued on is the decision to garnish the money. So it's the actual method of collection, not necessarily the overarching or collecting of tax. It's the actual way that it's been taken out of someone's account.
Okay, but the distinction I think is crucial. If you assume that the decision was based on an enactment, then your recourse should be the ADGR Act. If you assume, because the facts don't really expressly say, if you assume that the decision is based on the prerogative powers of the Commonwealth, then in that case, so it's not on an enactment, for example, then you would rely on the Section 39B of the Judiciary Act. So you could have those two, on the assumption that the decision is based on a statute, such as a tax law, and which is an enactment. You could probably look at the ADGR Act. If you assume that the decision was based on the exercise of implied powers of the executive to tax, because the power of taxation is always an implied power of the government, because no government is taxes are the lifeblood of every society. You don't need it in the Constitution. It's simply understood that every government has the power to tax. And so if you assume, therefore, that the power of the ATO here is on the basis of the exercise of implied powers and not on a statute, then your recourse would be the would be Section 39B of the Judiciary Act. Now, having said that, so we've clarified the source of the power of judicial review. The question is, what particular remedy are we looking at here? So, Michael, I think earlier was saying it's the writ of prohibition. Is that the only one that we look at?
Manjo, I was going to suggest a couple of others as well.
Yeah.
Initially, I was going to suggest also an injunction, like we said before, because he has a prima facie case. He will suffer injury, and that there's a legal and equitable right. The only thing the court would have to decide is that whether it balances the inconvenience or convenience of the parties. But also to quash the decision, you could have a writ of certiorari based on the fact that it's a breach of natural justice, or based on the jurisdictional grounds, basically. And so you could use a combination of writs and an injunction to try and stop the behaviour.
Okay, so I agree with the writ of injunction. I'd like to go back to the writ of certiorari that you pointed out, Sarah, in a short while. Okay, so the writ of injunction is a remedy that you could seek under Section 39B of the Judiciary Act, and in fact, what you're probably seeking would be an interlocutory prohibitory injunction. So it's interlocutory because in the absence of a final order, you're already seeking in the meantime, in the interim, the issuance of an injunction to prohibit the ATO from garnishing the business and personal funds of Darren. Okay, so you're applying for the issuance of a writ of interlocutory prohibitory injunction, as well as pointed out by Michael. You could also apply for a writ of prohibition, which are both available under Section 39B of the Judicial Act of 1903 Common Law. Now, Sarah raised a point of possibly a writ of certiorari. What do you think? What do the others think about that?
Well, it's a standard common law remedy, Manjo, so it's open no matter what the question here. Because it's common law, it can be applied in this sense, and it like as it says, it's got to be based on procedural fairness, which looking at this, it may not be procedural fairness. And the other thing is that it gives them the ability to quash the effect of what decision has been made at that point by the ATO.
Okay, very good point. I'd like to dig deeper into this issue about the answer raised by Sarah, because I think it's an opportune time for us to talk about the difference between common law or prerogative writs as opposed to equitable writs. What exactly is the distinction there? Is there even a distinction? Why are some considered to be common law writs or prerogative writs? And we also know that there are equitable writs such as injunction and declaration. Where's the distinction there? Are they actually one and the same?
No, because one is common law and the other one is under the Judiciary Acts themselves.
The equitable judicial remedies of injunction and declaration are actually part of the common law powers of the courts. Okay, except that they are equitable remedies. They're not based on statute. They're not based on the Judiciary Act. They're not even necessarily based on Section 39B of the Judiciary Act, because the writ of declaration, for example, is not available under Section 39B of the Judiciary Act. Neither is it available under Section 75(5) of the Constitution. It is an equitable remedy, in the same manner that injunction is. Although injunction, as an equitable judicial review remedy, is also a power given to the courts under Section 39B of the Judiciary Act. What I'm trying to clarify is, why do we distinguish, or why does there appear to be a distinction between common law judicial review remedies as opposed to equitable judicial remedies? Why?
Is it the fact that there's a historical difference? The fact that it basically goes back to when the King's Bench division basically issued the common law, and basically on the Judicature Act, it basically joined the two together. So that's why there is this still distinction, even though now equitable can come under common law jurisdiction.
Okay, yeah, the historical basis is correct, but why? Why did equitable, judicial remedies, come out in the first place? Why were they developed by the courts?
Isn't it because the common law is at the direction of the courts themselves? They don't actually have to follow through with any of those requests for certiorari or whatever else under common law, but under the Judiciary Act, it's a different story.
Historically.
So it's more about so it's more about the equitable remedies came about because of the inflexibility. It was very black and white historically with the other common law rights, where there wasn't any flexibility of the courts to tailor remedies to suit individual cases.
That's right. Sorry, I can't identify the ones who are speaking.
That was Darren. He's spot on. Good job, Darren.
Damien. Yeah.
Who did that? Who said that?
It's Damien.
Oh, Damien. So that's the correct answer there. Okay. So historically, as pointed by Sarah, it was the courts had asserted the right to control or regulate the excesses of the executive, and they came up with what are known as common law judicial review remedies. And that would involve, certiorari, prohibition, mandamus, and habeas corpus. But because they were part of the common law, in order for these writs to be issued by the courts, there needed to be certain requirements that had to be met. So, for example, in relation to certiorari, therefore, there was a requirement that the decision or an order had to be issued by an inferior court or a tribunal. So, in other words, if it is not an inferior court or a tribunal, such as an ordinary executive decision maker, you cannot have certiorari. So if a decision is made by a minister or by the secretary of a department of the executive, that is not a tribunal, that neither is that an inferior court. You cannot have certiorari. But more importantly, the other requirement of certiorari is that there are particular grounds that can be the basis for the issuance of writ of certiorari. It can only be on the basis of jurisdictional error, the breach of national justice or procedural fairness, it could be the ground of fraud or an error of law. So the grounds, therefore, are quite limited. But more importantly, the writ of certiorari can only be issued on the basis of what appears on the face of the record. So in other words, if you speak of a tribunal or an inferior court making a decision, they would usually have records, right? And these records then now need to be elevated to the higher court, to a higher court, a superior court. The superior court is limited to what is on the face of the record, what appears on the record, therefore. So any allegations that do not appear there, it cannot, you cannot have certiorari. The certiorari is limited to what is on the face of the record. And of course, if you're dealing with an executive decision maker, which is not a tribunal, that there won't be any record in the first place, because as we know, executive decision makers are not even required by law to provide any reasons for their decision. They can just come up with a decision. So certiorari, therefore, is limited to instances when a decision or order is made by an inferior court or a tribunal. So when you speak of a tribunal, that's a decision-making body, not part of the court system, but a decision-making body on the part of the executive. So it's a tribunal. So not any executive decision maker in general. Now, having said that as well, we see therefore that there's some rigidity, as pointed out by Damien, when it comes to common law judicial review remedies, because you need to meet this, you need to meet that, you need to meet this. Equitable judicial review remedies, therefore, historically came about because on the part of the King's Bench, people felt that they went to the courts, nothing was going to happen. The courts would deny the application because the applicant did not meet the strict requirements of the common law. Remember, the purpose of the common law came about as an attempt on the part of various courts in the UK to come up with a common law. That's what it means. It's a common law. So you had different judges all over. A lot of them were traveling, but they needed to develop a common law so they would know what the law is. And that's also why you have stare decisis, judicial precedents. But because there is a desire for judicial precedent, you need some uniformity in decision making. You know what I mean? You need some uniformity. That's what judicial precedent is all about. It means that there has to be some rigidity to the decisions made by the courts. They were rigid. So it means that even if the decision was unfair, you don't have a recourse under the common law. So if, say, the court said the writ cannot be granted because you don't have standing, then you're dead, you're done. But if you went to the king's bench, you appealed to the, to the exchequer of the king, they were more equitable. They looked at issues of fairness. Is it fair to do this? So when the king's bench felt that it was fairer to do this, they were willing to ignore the rigidity of the common law. That's why the equitable judicial remedies, review remedies came about, especially declaration and especially an injunction. And of course, we know through time that common law judicial review remedies and equitable judicial review remedies have somehow been melded together as one. And they all are within the powers of a court. But this distinction can still be important because sometimes you're looking at the appropriate judicial review remedy. Okay.
So we're suggesting in this case then, Manjo, that the end result is an injunction and a prohibition due to equitable remedies only?
It depends, because prohibition, as we said, is a common law remedy. Injunction is an equitable remedy. So you're applying, therefore, both for prohibition. Remember, prohibition is common law, it's rigid. So this was why, it simply says you're restrained from doing this. That's a prohibition. Stop. The executive is stopped from doing it. But the equitable remedy of injunction is important because it can be fashioned to meet the requirements of the individual. If you look at the writ of prohibition, for example, it is unlikely for the writ of prohibition to immediately be issued by the court. Why? It will have to look at the possibility of hearing. It's gonna have to hear the ATO. It might be too late in that case. You know what I mean? Before the prohibition can be issued, the court has to be convinced that the ATO, is about to undertake an unlawful action, in which case it may require a hearing. But if it will require a hearing and it's not going to issue the writ of prohibition in the meantime, then the funds of Darren Wilkins are going to be garnished. Are we clear? But with the writ of interlocutory prohibitory injunction, even in the absence of a hearing, the court will issue it straight away. If it is convinced that the balance of probabilities would favor the applicant getting the relief, and that the applicant is more likely than not to be entitled to the remedies that are being sought. So in that case, the interlocutory prohibitory injunction will be granted. But the writ of prohibition would still be important because the writ of interlocutory prohibitory injunction is just interlocutory. It is temporary, correct? The court will probably say, okay, this is valid for 30 days. But the writ of prohibition is almost a permanent writ. We should prevent the ATO from proceeding further. So you can see the distinction that how, taken together, they can be very important.
So does that mean, Manjo, I just want to clarify this. Sorry. Does that mean if we were stepping into a court, we'd literally have to go for an injunction and find out what period, and if we could win the injunction, let's say, then add on the common law of prohibition in the same court hearing? Or would this be two separate hearings, one for the injunction and then go back for the common law after the injunction had been set?
Let's clarify. You're using the word common law remedies, right? But actually here we're using Section 39B of the Judiciary Act. It is not the common law. So when you apply for a writ of prohibition under the facts, we're talking of the writ of prohibition under Section 39B of the Judiciary Act, because we're looking at putting a stop, restraining the executive from making a decision on the basis of its implied executive powers. Now, the equitable remedy, however, of course, is not under Section 39B of the Judiciary Act, which is why you're seeking recourse under the equitable powers of the court, the power of issuing an injunction. The injunction is also a bit more difficult because what will traditionally happen is that the court will say it will issue the writ of injunction only if this happens. One, you probably have to post a bond. Two, it's only going to be valid for, let's say, a period of 2 weeks and so on. So there are there will be conditions imposed by the courts. Did that make sense?
Yeah, it makes sense. I'm just trying to work out if you were to step into a courtroom, if you're going to do the Judiciary Act for the injunction, then how are you going to deal with prohibition in the same context? Like, is this going to be two applications before the court, or could you do it all within the one application? That's the question.
It's going to be one application. You're dealing with one application. Remember, when you look at the Judiciary Act of 1903, you're looking both at prohibition and injunction. So actually, under the Judiciary Act of 1903, the distinction between a common law judicial remedy and an equitable judicial remedy has disappeared, because it is under Section 13(b) of the Judiciary Act. It is also under Section 75(5) of the Constitution. The emphasis I'm trying to make is that if you base it on, remember, the exercise by the courts of the power of judicial review, whether it's prohibition or injunction, is based on the common law. In other words, it's based on the previous practices of the courts. If it is based on the previous practices of the courts, in relation, therefore, for example, to the issuance of writ of prohibition, there will be rigorous requirements before the court will issue the writ of prohibition. On the other hand, if the court is attempting to issue a writ of injunction under Section 13(b) of the Judiciary Act, the idea of the court is really to try to prevent unfairness, trying to make sure that the rights of an applicant are being protected. So as an equitable remedy, because that's the nature of an injunction, the court is then more likely to try to fashion the proper order that would protect the interests of the applicant.
Yeah, the reason I asked that question, Manjo, is the same reason that Michael just posted up. He said prohibition won't be heard at the same time as the injunction. Otherwise, the injunction is pointless, isn't it?
Oh, is that what you're saying?
Yeah, that's why we're asking.
About the hearing.
Yes, you have one application for both, and you do 2 hearings. You're going to go and get your injunction, and then it gives you time to get your prohibition. You're not going to get a full hearing as quick as you can.
That's right. That's right. But remember, what we're talking at this point is what remedy you're asking for. We're not talking about the hearing. We're not going to get into the details of, how do you apply for an injunction? How do you apply for a writ? We're not talking about that. The only question for us is, what are the remedies? That's it. Don't overcomplicate things, okay? Because that's talking about perhaps civil procedure, okay? When you get into the nitty-gritty of, what you need to do in order to get a writ of prohibition, we're not there. We're simply saying that, the writ of prohibition is available for these reasons, and the writ of injunction is also available for these particular reasons. Okay, so we're good. We could move on. It's 7 o'clock. We've only covered 2 questions. So Michael, bye. See you soon. Thanks for your engagement. Are you happy to go on? Okay. Now, if people need to go, Mike needs to go. If people need to go, I would understand, because we took longer than expected. Okay, let's proceed. Let's go to question 2. Can I get somebody to read question 2 for us?
I'll do it, Manjo.
Thank you.
The Francois Mills company applied for a broadcasting license for the Australian Broadcasting Agency, ABA, and to be allowed to post a bond of $500,000 for the license. Under Section 43A of the Australian Broadcasting Standards Act, Commonwealth, a broadcasting license shall only be issued by the ABA upon payment of a bond of $5 million by an applicant for a license. Section 43B of the Act also provides that the ABA Board has the power, which it may or may not exercise, to reduce the amount of the bond required under Section 43A of this Act. The ABA refused to issue a license to Francois Mills until it posted a bond of $5 million. Francois Mills has approached you as a solicitor for advice. Advise the company on the judicial remedy or remedies that might be available over the ABA decision.
Okay. What do people think? Advise the company of the judicial remedy or remedies that might be available over the ABA decision.
I had a go at this one earlier, and I'm confused. I don't think, it obviously seems to be pointing towards something like Mandamus or something, making them exercise a power. But because it's a discretionary power, I just don't see how you can force the government to exercise the discretion, because then it's not a discretion.
Go on. So what would your advice be, Damien?
My advice would be that they don't have any grounds for judicial review at all.
That would be correct. That would be my view as well. I would, like you, I would advise a company that judicial review remedy, there is no ground for judicial review, because it involves the exercise of a discretion, and so therefore there is no judicial remedy involved in this instance. So what it simply means is that you cannot, judicial review is not always available, as we know, to every single executive decision, such as this one, because the ABA is simply exercising a power which has been given to it, and the exercise of a discretion is not controllable by the courts. We know that already, right? That's a matter of law. Okay, very good. Question 3. Can I get somebody to read the question?
Yeah, right, I'll have a go. Okay, the Security Workers Act requires anyone seeking to practice as a security worker in the Commonwealth Department, agency or office to obtain a licence from the Australian Department of Social Services and to meet certain requirements relating to education and training qualifications and physical and moral fitness. Sherlock Gordon applied for a security worker's licence with the ADSS in compliance with the Security Workers Act. His application was denied, however, because he appeared fat, although his body mass index showed he was of normal weight. Sherlock has come to you for legal advice about the DSS decision.
Thank you. What would your advice be? And remember, when asked for legal advice, it has to be a thorough answer for the purpose of the final assessment. You can't just say, apply for judicial review or not apply for judicial review. It has to be thorough.
Hi, Manjo. I'll take a stab. Because it's made under an enactment, I would say apply for under the Administrative Decisions Judicial Review Act on the basis of the grounds of a number of grounds, really, that the fact natural justice, I would say, as being one. And on the basis for remedy, I again would...
Wait, before you go to remedy, Sarah, can I just clarify the ground?
Oh, sorry, the ground, sorry.
Natural justice. Why is there a breach of natural justice here?
What was I? Sorry, hang on 2 seconds.
I would say natural justice too, just because it's in these sort of contentious ones, it's always a good answer to go for, because it's a good catch-all for heaps of stuff.
No, it's not. I mean, it's easy, but why would there be a breach of natural justice? Is Sherlock actually entitled to a prior hearing before the ADSS denies his application for a license?
No, sorry, I was thinking more along the lines of would it be like more of a question of law, in the fact that because it's a jurisdictional fact, would his body mass index necessarily mean that he's not? We were talking about it the other week, whether it would be an error of law or something along those, as a question of law.
Why would it be an error of law?
Sorry,
lack of evidence.
Huh?
Yeah.
Lack of evidence. Because it was the judgment was based on just an appearance of being fat, and there was no.
Okay. Possible. What other ground is there? So that's acceptable. There appears to be no evidence to make a decision that he is fat, given that his body mass index is normal. Although, isn't it possible to have a normal body mass index and yet appear fat? Isn't that possible? I don't know. Probably is.
Yeah, but the point is, so the requirement is that you've got to meet certain physical fitness levels, right? Mm-hmm. But if the determination that he hasn't met the physical fitness level was based on just, well, it says because he appeared fat, so it was based on a visual inspection.
Yeah.
I would say that's making a decision without proper evidence,
and it's unreasonable. It's unreasonable.
It's probably unreasonable, right? I mean, you judge somebody as not meeting the requirements about physical fitness because he appears fat, when in fact his BMI appears to be normal. That seems unreasonable. So those are the grounds. So maybe lack of evidence, and given the fact also that the question of what is fat might in fact be a legal question, okay? But that's related to the issue of no evidence. But the other aspect is it seems to be an unreasonable decision. So having said that, what remedy, judicial review remedies, would you probably apply for?
And take your pick under the ADGR Act, section, I don't know, whichever one covers unreasonableness.
Okay, so what particular remedies? What particular remedies?
I'm going to have a stab, Manjo, and say Mandamus to get them to actually act and to actually check out the evidence properly.
Okay, on that note, you don't even have to use the word Mandamus because you're relying on the ADGR Act. So you probably use Mandamus if you're relying on Section 13B of the Judiciary Act. But here, because you're relying on the ADGR Act, what legal concept are we using under the powers of the Federal Circuit Court or the Federal Court of Australia?
A decision that's unreasonable.
Okay, but what particular order are you applying for to be issued by the court?
Is it to compel them to review their decision? Is that what he's trying to get at?
I mean, Sherlock has come to you for advice. The question is, what advice would you give in terms of the judicial review remedies? So to be more specific, relying, for example, on Section 16 of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, Sherlock can ask for an order, for example, quashing the decision or setting aside the decision not to grant him a license. That could be one. That's in the language of Section 16(1)(a). It could also be to asking for a declaration that he has a right to a license. Or thirdly, it may be to ask the court to direct the ADSS to grant him a license. Because if he is entitled to it, then the ADSS cannot refuse.
Yeah, but is he entitled to it? Because he's applying for a license. It's only an application. So that would strike off the last one you just mentioned, wouldn't it, Manjo?
That's right. But if a person, just because a decision has to be made doesn't mean a person is not entitled. If a person meets the qualifications, the decision maker has an obligation, as a duty, to issue it. So if there are 5 requirements, for example, and you meet it, and the decision maker refuses to perform the duty to issue you a license when you're actually entitled to it, ordinarily you would have been entitled to Mandamus if you relied on Section 13(b) of the Judiciary Act. For example, an entitlement to a visa. But here, because you're relying on the ADGR Act, it is simply relying on Section 16(1)(b) of the ADGR Act, which is for the court to direct the ADSS to grant the license. It's actually the nature of a Mandamus, but you don't use the word Mandamus here because because you're relying on the ADGR Act. So you're asking the court to compel the ADSS to issue the license. So in other words, the point there is that if an applicant meets the requirements, for example, for a license, or meets the requirements to particular benefits, okay, and there is no discretion on the part of the executive to deny the issuance of the license or to deny the giving of the benefits, because therefore it is a matter of right on the part of the applicant, the court can direct the decision maker to grant the license or to grant particular benefits.
So I'm just trying to find the difference here and clarify it, because I mean last week or the week before we did that one where that lady was rejected her higher education, right? And that was because it was not a government institution. Is that the fact? Like here it's a Commonwealth Act, whereas previously with that other lady it was just a no by the actual education, the university itself.
I can't remember the facts there, but if you rely on
well, because she met all the qualification material apparently, but somebody had made the statement that she cheated on her final exam or something, and they wouldn't let her in for her PhD studies.
Okay. I can't remember the facts there, but if it was on that basis, I don't know the facts now, okay? But it is possible that the judicial review might not be available. For example, if there is in fact evidence to support the decision. If there is evidence. Here we're talking of there is no evidence. Okay, that's one. Secondly, if there is discretion on the part of the executive to deny something, then you cannot have recourse to judicial review. Under the facts here we're looking at in question 3, it seems to be apparent that Sherlock Gordon is entitled as a matter of right to the license. That seems to be apparent here. He is entitled to it as a matter of right. And if therefore the ADSS refuses to issue it to Sherlock Gordon, when in fact Sherlock Gordon is entitled to it as a matter of right because he meets all the qualifications, then the court can order the ADSS to grant him a license.
Can I just jump in, Manjo? I know what you're saying there, but I do remember reading somewhere in the textbook about how you've got to be very careful about how you word your application in that regard, because you don't actually, because of the restrictions because it's judicial review and they don't stand in the shoes of the decision maker, because it's not like merits review. Yeah. But so basically, when you're getting your writ, it's not actually technically the court saying, like, the court isn't directly issuing the license, but they're basically saying that the legal, they sort of kick it back to the decision maker to basically say, well, the legal decision you need to make here is that he's allowed to have a license. So it's not like, and I think they give the example in the textbook of like a refugee visa case, yes, where the court didn't say, the court weren't allowed to say, oh, that person was allowed to have a visa, or like a refugee visa. Yes. What the court were allowed to say was the person is a refugee.
That's right.
And then, therefore, then it goes back to the original decision maker. The original decision maker, like the Minister for Immigration or whatever, then goes and makes the decision based on the fact that they've been told by the court that they are definitely a refugee, and then make the decision again. So
that's correct, Damien, but it's not contradictory. Because
I just think is it? Am I just understanding that bit right? Where you've got to be careful about like when we're giving advice, the advice wouldn't be that, oh well, the court is giving you a license. It's that the court are basically directing the decision maker that the only lawful decision is that you get a license.
So what we need to remember is that if you look at Section 16(1) of the ADGR Act, the court has the power to direct any of the parties, to do what is necessary to do justice between the parties. That's a broad term. To direct. That's actually the nature of a mandamus even. So remember, we don't use the word mandamus in the ADGR Act because remember, the purpose of the ADGR Act was actually to address the limitations of the common law judicial review. There were so many restrictions there. That's why they had the ADGR Act. So if you are therefore a lawyer, you should try to apply for as many possible orders that you could, for as long as you have grounds for making that application. So you ask for a quashal, you ask for a declaration of a license, you ask for the ADSS, for the court to actually direct the ADSS to grant the license. Now, in this particular context, the reason why we're able to make these particular applications is because it would appear that Sherlock Gordon is really entitled to the license as a matter of law. Now, in the circumstances that Damien had pointed out, following, for example, the case of Green versus Daniels, the circumstances there were different because it wasn't clear-cut that a person was in fact entitled to particular benefits. It had to be reviewed by the executive on the basis of certain facts, and then there was also the element of discretion. Here, there is no element of discretion. Here, if a person meets the qualifications, the person is entitled to a license as a matter of law. In the same manner that if a person meets the requirements for particular benefits and the benefits are not granted, then in that case, there is a possibility that, Mandamus might lie in the event it's Section 39B of the Judicial Act that is applied, that is the basis for judicial review.
So in Damien's case, Manjo, is it almost like saying the court is making a declaration on the legal issues and the legal facts? Like they're telling the government basically in this case that, look, you've got to make a different decision. But so they're making a declaration. But as we know, and Jackson's all pointed out, that this is where it gets confusing because the judiciary is not allowed to stand in the shoes of the decision maker.
That's right.
And ultimately what you're saying is they're not standing in the shoes. They're actually making a declaration to say that they need to reform their opinion and change how the decision has been made.
Good point, Nicholas and Jackson, but that's exactly the whole point. When a court issues a declaration, the court is not, in fact, stepping into the shoes of the decision maker to make a particular order to grant particular benefits. For example, it is simply saying that this applicant is entitled to, this particular right. And therefore, it is up to you now as the executive to issue the order. It is not the court issuing the order. It is simply the court declaring that this person is entitled to a particular right. I leave it to the executive to issue the order. That's in the nature of a declaration. But the other point that needs to be emphasized is that because if you talk about declaration as an equitable judicial review remedy, it is not always available. So the court will not, step in to make a declaration as to pre-existing rights when it is not clear that a person is entitled to certain rights. It will not make a declaration. Only when it is apparent to the court that a person is entitled to particular rights may the court issue a declaration, because otherwise it will leave it to the decision maker, one, to make a decision whether or not an applicant is entitled to certain rights, but number two, to determine whether to give particular benefits on the basis of those rights. So those are two things: determining whether the right exists and then making an order to grant particular benefits that relate to those rights.
Yeah, so in this case, we'd be asking the court for a declaration. Like, is that what we're saying? Yeah. In this case, he has standing, so we would ask the court for a declaration.
Yes. So it's an alternative remedy, so that if the court refuses, because the court can refuse. Remember, when you ask the court to direct the ADSS to grant the license, it's actually in the nature of stepping into the shoes of the decision maker to act in a particular way. And remember that as far as judicial review remedy is concerned, in general, courts do not try to substitute their decision for that of the decision maker. But it is available under Section 16. So what you're saying, in the event the court refuses to direct the ADSS to act in a particular way, in this case to issue the license, you have a backup remedy, which is to ask the court to at least make a declaration that Sherlock Gordon is entitled to the license. And if the court makes that declaration, it will now be the duty of the part of the executive to make a decision that is consistent with the court order, recognizing the right of Sherlock Gordon. Okay, so from Jackson, would it be fair to say the court is making a recommendation of a correct decision? That's correct. So the nature of a declaration is almost a recommendation to the executive decision maker that this is the correct decision. But the court is not implementing its decision, the decision it's making. It is still leaving it to the decision maker. Okay? So it's one thing to say, yes, you're entitled, but I cannot give it to you. That's Green versus Daniels. That's in the nature of a declaration. So the court in Green versus Daniels was saying, yes, I know I'm making a declaration, you're entitled to it, but I cannot grant you this order because that is up to the executive to do. But on the basis of this declaration, the executive has to be guided already by the court order that there is in fact a right that is available to a particular applicant. Okay. Question 4. Can I get somebody to read question 4? Are you happy to go on? It's 7:22.
Yeah, keep going, Manjo. This is like this subject is really intensive the more we seem to get into it. And I don't know about everybody else, but what I'm finding is there seems to be more than one resolve. And as a lawyer, you're going to need to come up with every possible resolve there is when you step into that courtroom.
Very good. Okay, so we can go on. Question 4. Can somebody...
Yeah, I'll read it out. The Business Regulation and Control Act, Commonwealth, requires that before a person or persons may engage in business or a commercial activity, prior registration must be secured from the Australian Business Regulatory Agency. The Act provides that the agency has the power to shut down a busy or commercial activity that operates without being registered with it. In addition, the agency may also seize documents, papers, goods, properties and assets belonging to an unregistered business and impose a fine. The Act is silent on whether prior notice must be given by the agency before seizing the documents, papers, goods, properties and assets belonging to an unregistered business. Aaron Lamb has been operating a small business for some time by selling his handmade goods to customers online. However, he failed to register with the Australian Business Regulatory Agency, and in February, representatives of the ABRA came to his house without notice and seized his goods, documents and papers. They informed Lamb that his goods, documents and papers would only be returned after he paid a fine of $10,000. Lamb has come to you as a solicitor for advice.
What advice would you give him? What advice would you give him?
Yeah, so we looked at this sort of stuff a little while ago. I can't remember off the top of my head, but the government can't just that's right. It's excessive use of power. So they might they might have discretion to do stuff, but it's not unfettered discretion.
That's right.
To do whatever they want. And so there's a common law right to property. They can't just come in and take your stuff.
Very good.
So, yeah, so you would apply for judicial review based on those grounds. And you would obviously, because it's after the fact, right? Are they? Hang on. Have they already taken the stuff, or are they saying they're going to?
They've gone to the house and taken the stuff.
Okay. So obviously prohibition is pointless because it's already happened.
But is that correct, Damien? Prohibition is pointless because the goods have already been taken. Is that really correct?
That's just based on my general sort of view of it. It stops something from happening, but it can probably.
The effect of the court issuing, an order in the nature of a prohibition. We're not talking of prohibition here because we're relying on the ADGR Act. Do we agree? So we're relying on the ADGR Act. But
yep.
So if the court issues an order quashing the decision of the Australian Business Regulatory Agency, what would be the legal effect of such an order quashing the decision?
Yeah, so it.
Pointless or not?
Yeah, so the so the quashing basically invalidates, or it's
That's right.
the legal consequences of a decision. It invalidates the consequences, so therefore you can get your stuff back, I suppose. Yeah.
Very good. So that's good. So if thank you, Damien. So if I were the lawyer, the advice clear would be to apply for judicial review under the ADGR Act because the decision is based on an enactment. There are at least two grounds. One is the breach of the right to natural justice. He hasn't been given an opportunity to be heard, and this is a property right, which in the case of Antic versus Carrington is recognized by the courts. That if a person has property rights, he must be given an opportunity to be heard before his goods can be seized. But at the same time, this amounts to unreasonableness in the exercise of the powers of the agency, because even if it's argued that the agency has certain powers, the exercise of this of those powers must be done reasonably. So if there is a less oppressive means of doing it, then that should be the recourse of the executive. Now, having now cited the fact that there is a ground for judicial review, as pointed out by Damien, you would ask the court to quash the decision of the agency, because the quasher will mean that the order is ineffectual and invalid, so that the agency will have to return the goods. But at the same time, it can ask the court to order the agency, for example, to immediately return the goods and take other steps that would protect, for example, the interests of Aaron Lam. Okay, very good. Thank you for that, Damien. Question 5. Okay, everybody's dropping out. Question 5 is just a repetition. I'll skip that because this is close to Green versus Daniels. Oh, it's the same thing. We've actually covered this, I think. Have we? Okay, can we just go through question 6? Thanks, Jackson. Question 6. Can I ask somebody to read question 6?
Yep. Okay. After finishing a diploma of community service work at the Goodness Good Technical Institute, Sherlock Gordon applied for a social support worker's licence with the Australian Department of Social Services. The DSS imposed this requirement on the basis of its implied executive powers to regulate the social support services offered by the department. The DSS requires anyone seeking to practice as a social support worker to obtain a licence from the DSS and to meet requirements as to moral fitness. Gordon submitted all the requirements, including a police clearance that stated he has no record of any criminal conviction. The DSS, however, informed him in a letter that it could not issue him a social support worker's licence. No reason was provided. He has come to you as a solicitor for advice. What advice would you give him?
Mm-hmm. Final question, 7:30.
Off the top of my head, there's no inherent right for people to get the reasons for a decision.
Okay.
So I don't think, like at first blush, I don't think there's any ground for judicial review, but I don't know.
Mm-hmm.
There's no implied right to the license either, so he has no grounds for a review at all.
But I thought earlier I said that if a person actually meets the requirements as a matter of law, that person will be entitled to the license. It will be unreasonable for the decision maker to refuse to issue a license to which a person is actually entitled to. Are we saying that Sherlock Gordon in this instance is not entitled to the license? I thought he met the requirements there. Let's assume that he meets all the requirements because he seems to meet all the requirements. So let's just be clear with the facts. Let's assume that Sherlock Gordon meets all the requirements as far as he knows. The DSS has not said that there is, that Sherlock Gordon fails to meet any of the requirements. So the DSS has not said that. But we know, it would appear that Sherlock Gordon meets all the requirements. And yet, the DSS refuses to issue the license. What now? Does it mean that, Sherlock Gordon can't do anything by going to the courts?
Well, he can't use the ADJR Act because it's based on, the decision was based on implied executive powers. That's the issue, right? It's not under an enactment, so we can't go to the ADJR.
Yes, go on. So there is no ground. You can't apply for judicial review. Is that what you're going to be advising Sherlock Gordon? So Sherlock Gordon said, So even if the executive acts in a reasonable manner in refusing to issue a license, the applicant for a license who gets a refusal is stuck. He can't do anything. Is that what you're saying?
No, I'm not saying that. I'm just saying in this instance, because it's an executive power to make the decision, he can't apply for judicial review under the ADJR Act.
Yeah, that's fine. So imagine putting this in a situation you're applying for a visa for your girlfriend or whatever, and the visa has not been granted, and it seems to be like there is no reason why for the denial. It seems like a person is entitled to it. You have no recourse to the courts. Is that what we're saying? What if it is yours as a matter of right? It could be particular benefits you're entitled to. So Centrelink, you're entitled to benefits from Centrelink, for example. But Centrelink says it's not going to give it to you anyway. Does it mean you're stuck? You don't have any recourse? Assuming that we're not talking of the ADJR Act. What do you think?
Yeah, okay. So it'd be like a ground of unreasonableness or something? Yes. Something general?
Yeah. So that would be the ground.
Yeah.
But don't we have to prove unreasonableness? How do we do that in this instance when nothing's been provided?
No, but of course you're going to ask, you're going to exercise your rights perhaps under Section 13, but you couldn't because the ADJR Act does not apply. But it doesn't prevent you anyway from complaining that the decision of the decision maker is unreasonable. Why would the decision maker refuse to issue a license when it is clear that Sherlock Gordon meets all the requirements? In other words, as a matter of law, Sherlock Gordon has the right to the license. That's the allegation we're making. And therefore, if Sherlock Gordon has the right to the license as a matter of law, and the executive refuses to issue that license, then the decision of the executive is unreasonable. It is a decision that no reasonable person or authority would arrive at. So you have
I'd have to ask for an internal review or a merit review, wouldn't I?
I mean, that's fine. That's fine. But let's assume that, that's not working for you. We're really looking at judicial review remedies here. So let's assume that the ground here is unreasonableness. There is Wednesbury and reasonableness. Because if a person is in fact entitled to a license, that license should be granted to that person as a matter of right. The executive cannot just deny somebody a right that that person is entitled to. That would be unreasonable. Okay, it's like, withholding your salary. If it is yours as a matter of right, the executive cannot just withhold it. That would be unreasonable. In two senses of the word. Unreasonable in the sense that, it could be the oppressive exercise of a power that might exist, but it is unreasonable anyway. So if we know that there is a ground for judicial review, finally, what is the judicial review remedy? It is the writ of Mandamus under Section 39B of the Judiciary Act of 1905.
That's, I was just going back over Mandamus just to qualify whether that was it. I think that is it, but I'll need to read a bit more.
Yeah, so you should give an advice that you should apply that, Sherlock Gordon will apply for a writ of Mandamus with the Federal Circuit Court to compel the DSS to issue the license to Sherlock Gordon, because Sherlock Gordon is entitled to it as a matter of right. And therefore, if Sherlock Gordon is entitled to it as a matter of right, then there is a corresponding duty on the part of the executive, the DSS, to issue it. And in this particular case, the DSS has failed to perform a public duty, which is to grant the license to Sherlock Gordon. And you can examine the case of Commissioner of State Revenue versus Royal Insurance Australia Limited, which involved an application to compel the Commissioner of State Revenue for Victoria, for example, to issue a tax refund. But the Commissioner of Tax Revenue said, no, we're not issuing it. But it was a matter of right. And so he applied for a mandamus, and the writ of mandamus was granted because it was a matter of right. Okay. So that's it, 7:38. Any questions before we end tonight's tutorial?
No, all good. Thanks very much.
Thank you very much. So thanks for the active engagement. It's, I think, time for dinner for all of us. I look forward to my own dinner as well. So thanks everyone. I'll see you again next week on Thursday. And thanks for being very actively engaged in tonight's tutorial as usual.
All right.
Thank you. See you soon. Bye.
Thanks, bye.
Bye.